So as an advocate, I came across a medical certificate which appeared routine at the first glance. On a closer scrutiny, it lacked essential medical as well as legal requirements in it, which raised serious concerns with regard to the reliability as well as on what basis the medical certificate was issued. So this incident highlights real yet crucial reality. We often treat medical certificates as routine paperwork. However, the law treats it as evidence. The moment your document reaches the courtroom, it no longer just expresses your opinion as a doctor. However, it becomes a document that may influence adjournments, bail jurisprudence, compensation claims, and even the outcome of a case. And if in particular any doctor furnishes a false affidavit on a material fact, implications of section 234 of Bharatiya Nyaya Sanhita will follow, which provides that doctor shall be punishable in the same manner as that of any other person which will furnish a false affidavit before the honorable court. But that's not all. Even the medical profession ethical framework even imposes certain duties upon the doctors. In particular, clause 7.7 of Indian Medical Council Regulation 2002, which is still relied upon under the current regulatory framework, provides that whenever such certificate is to be furnished for court reference or either for administrative purposes, it must not be in fact untrue, improper, misleading. And any breach with regard to the same would not just amount to misconduct, but also invite disciplinary proceedings against you in addition to the criminal consequences. So rather than merely advising doctors, I will give you a checklist of 5-6 points which will help you to avoid unnecessary litigation in future. First, never issue a backdated medical certificate unless you have a record or a solid proof to substantiate your claim. Second, personally examine the patient yourself before attesting to his illness or fitness. Never give certificate just merely upon a request or as a favor. Third, properly identify the patient. Mention the essential details of a patient, for example, his name, age, gender, identification mark, so that the certificate cannot be challenged later on. Fourth, this is the most important one, that record the findings of your conclusion. Don't just conclude the medical certificate saying that fit or unfit. Give a valid explanation as to how you have reached to such conclusion. Fifth, always preserve a duplicate copy of the medical certificate that has been issued by your office, because it will help you if in case maybe years later some dispute arises with regard to the same medical certificate. Your duplicate copy will help you then and there. Sixth, remember that every medical certificate that you issue could someday come under scrutiny and you have to defend it under oath. So if you are not able to explain every word contained in that certificate, never certify it. So drafting a medical certificate may take even 2 minutes. However, defending it in a court can take up to 2 years. The doctors usually carry two responsibilities, one towards their patient and the other towards administration of justice. Being a bit cautious while discharging their duty of issuance of medical certificate can protect both of them. So follow for more practical legal awareness videos, because learning the law before the dispute, I guess, is much important and better than learning the law inside the courtroom.